Hello everyone. So today in this lecture we are going to discuss about the article 13, that is the law inconsistence with the FR, fundamental right. So article 13 is the judicial review article of the constitution. So basically the purpose is to protect fundamental right. And so what was the purpose, like the purpose of article 13? So purpose is that it is to ensure constitutional supremacy and it protects fundamental rights because it limits legislative power and established judicial review. Okay, what does it do? It limits legislative power and it established what? Judicial review. Okay, so this is what is the purpose, is to establish judicial review, and because it ensured that the fundamental rights are supreme and any law violating them can be declared void. Okay, now there are basically 4 clauses under the article 13. So we will discuss about each clause one by one, or we can read it simply from the given article. Like if we read the first one, that is the article 13 clause 1 deals with pre-constitutional law. What does it deal with? Pre-constitutional law, like laws those which have been existed बिफोर 26 जैन 1950 के पहले जो भी लॉज होंगी ये उन पे अप्लाई होता है. मतलब कि if there is a law that is inconsistent with the fundamental right, then that law will be void. Okay, then the law will be void. Okay. And the second, that is the article 13 clause 2 talks about the post constitutional law, that is the state shall not make any law violating the fundamental right. If by the way state makes any law, then that law will be void. Okay, so if you read them, that all law enforced in the territory of India immediately before the commencement of the constitution. Okay, तो मतलब कि प्री कॉन्स्टिट्यूशनल लॉस द स्टेट सेल नॉट मेक, और सेकंड में अगर देखोगे द स्टेट सेल नॉट मेक एनी लॉ, स्टेट सेल नॉट मेक एनी लॉ दैट टेक्स अवे और अब्रिजेस द राइट कन्फर्ड बाय दिस पार्ट. ओके, मतलब कि पोस्ट कॉन्स्टिट्यूशनल लॉ, मतलब स्टेट कोई भी ऐसी लॉ नहीं बना सकता जिससे आप उसके फंडामेंटल राइट को वायलेट करो. सिमिलरली अगर हम जाएंगे आर्टिकल 13 क्लॉज 3 पे, तो देर आर 2 सब क्लॉज अंडर आर्टिकल 13 क्लॉज 3, दैट इज सब क्लॉज ए, सब क्लॉज बी. अंडर सब क्लॉज ए it defines the meaning of law. What does law includes? So basically law includes ordinance, order, bylaw, rules, regulation, notifications or customs or usages having in the territory of India. Okay, and the article 13 clause 4, the clause 4 states that the nothing in this article shall apply to any amendment of this constitution made under article 368. That is, it's basically it was added, it was not there, it was added by the 24th Constitutional Amendment Act of 1971, and it states that the constitutional amendment made under article 368 are not considered law under article 13. Okay, now we can discuss one by one each clause. Okay, so article 13 clause 1, that talks about what? Pre-constitutional laws. Okay, that is that laws existed before 26 Jan 1950. If they are consistent with the fundamental right, they will continue. If the law is inconsistent with fundamental right, then it will be void only to the extent of inconsistency. That is, for example, if we take an example, like suppose कोई ब्रिटिश एरा लॉ है that restrict, जो हमारी रिस्ट्रिक्ट करती है इसको, restriction upon the freedom of speech. Okay, but constitution commencement after the constitution, only the offending portion become void, only the offending portion become void. So there comes a doctrine, that is the doctrine of Eclipse. Which one? Doctrine of. So what does basically doctrine of Eclipse means? Basically it applies to pre-constitutional law if inconsistent with the fundamental right, no, it become dormant. Okay, like if there is a law, pre-constitutional law, and that is inconsistent with the fundamental right, then that law is not completely dead, it becomes dormant or eclipsed. Okay, if inconsistency removed, the law revives automatically. That is, it was given under the Bikaji Narayan case. Okay, 1955. Now we will read about the article 13 clause 2, that talks about the post constitutional laws. Okay, that is, the state, suppose if a state makes a law, then if the law is consistent with the fundamental, then it will be valid. If it violates fundamental rights, if it is consistent with fundamental rights, then it will be valid. But if it violates fundamental rights, then it will be void from the beginning, void ab initio, that will be void from the beginning. And there comes another doctrine, that is doctrine of what? Doctrine of severability. That means, what does it means? To separate the valid from the invalid. Okay, like suppose a law has some valid provision and some invalid provision. The invalid provisions that violate fundamental rights, then the court remove only the unconstitutional part. That is, the remaining law will survive. Okay, that is the doctrine of severability. For example, if in an act there is suppose a section, if there is suppose a section 5 that is unconstitutional, okay, then only the section 5 will struck down and the remaining act will prevail and survive. Okay, and then there comes another doctrine under the article 13, that is the doctrine of what? Doctrine of waiver. Basically, can a citizen waive off their fundamental right? क्या एक इंडिविजुअल सिटीजन है वो अपने फंडामेंटल राइट्स को वेव ऑफ कर सकता है? देन द आंसर इज नो. फंडामेंटल राइट्स आर फॉर पब्लिक वेलफेयर एंड कॉन्स्टिट्यूशनल गवर्नेंस. ओके, सो वी कैन नॉट वेव ऑफ. द सिटीजन कैन नॉट वॉलंटरी surrender fundamental right. That is doctrine of waiver. Can a citizen waive off their fundamental right? The citizen cannot voluntarily surrender fundamental rights. Okay, now we have discussed the two clauses. Then now the third clause, that is article 13 clause 3, that talks about the what? Meaning of law. The meaning of law includes what? The act of parliament, state legislations, ordinances, rules, regulations, notifications and orders, bylaws, customs having force of law. Okay, and then the last one is what? Article 13 clause 4. Basically, article 13 clause 4 is been added through the 24th Constitutional Amendment Act, but there is a series of events, like there was one Shankari Prasad case, so in 1951, so where the court said that the amendment under article 368 will not be treated as law, है ना? That means the parliament can amend fundamental right. Later on there comes the Golaknath case. In Golaknath case in 1967, court override the Shankari Prasad and Sajjan Singh's case judgment, and it said that the amendment under article 368 are to be treated as law under article 13. That's mean that parliament cannot amend fundamental right. And after this, the parliament amend the constitution through the 24th Constitutional Amendment Act in 19, and basically it inserted the article 13 clause 4 that says that the constitutional amendments are not covered under article 13. क्या है कि अंडर आर्टिकल 368 जो कॉन्स्टिट्यूशनल अमेंडमेंट्स हैं वो आप अंडर आर्टिकल 13 के अंडर लॉज में कवर नहीं है. ठीक है, मतलब कि पार्लियामेंट के पास पावर आ गई कि दे कैन अमेंड फंडामेंटल राइट्स. ओके, बट देयर कम्स एन वेरी इंपॉर्टेंट केस, दैट इज केसवानंद भारती केस. In 1973, the Kesavananda Bharati case, the Supreme Court said that the Parliament can amend fundamental right, but it cannot destroy the basic structure. So it established what? Basic structure doctrine. So we have covered the Article 13. Now what was there in the Article 13? So basically under Article 13, it was said that the state, what is state here? State that is defined under Article 12. The state cannot make any law. The state cannot make any law that violates fundamental right. Okay, cannot make any law that violate fundamental right. If state makes any law that violate, then the law will be what? Then the law will be null and void and struck down. So, and the definition of law is defined under Article 13 Clause 3. And the state cannot make any law that violates fundamental rights. That means there are two clauses under Article 13 Clause 1 talks about the pre-constitutional law, and under Article 13 Clause 2 talks about the post-constitutional law. Like, if there is any pre-constitutional law that violates fundamental right, then that law will be null and void. If there is a post-constitutional law that violates fundamental right, then that law will be null and void. Okay, thank you.